revolution, and some of them have to do with terminology, because we have to learn new words which do not have legal content or which did not have legal content and now have it. And of course, we identified transitory challenges like the ones you've displayed there. Digital illiteracy, I don't know if it's transitory or it will be permanent, but something can be done to improve them, or training of judges and lawyers, and permanent ones, which of course relate to the impact of new technologies into the field of human rights and procedural safeguards. Magne Strandberg is also not present here. He wrote the chapter on evidence and the impact of the digital revolution on evidence. His findings were presented in the midterm conference, so I won't address them here. Well, he tried to adapt the general categories of evidentiary law to the field of digital evidence, and he, considered that main categories are useful, although, of course, adaptations will always be needed. I also presented the main findings of my chapter last March. I am addressing the evolution from remote hearings to online courts. I'm discussing how something which was initially used in a context of health emergency now is going to be used and broadly used for efficiency purposes. So we are addressing how legal orders are tackling the challenges of this functional equivalence, digital immediacy. How do we address the problems of public proceedings? And how do we find the balance between the powers of the court to decide whether the format of a hearing is going to be virtual, hybrid, or face-to-face, and the resistances or the powers of the parties in order to decide the format of a hearing, and then the evolution from online proceedings to online courts themselves. So what will happen when courts cease to be a physical space and they will turn into platforms? And how are we going to face the situation? And what we are finding, we're discovering in this the chapter is called Digital Revolution. I would say it's rather digital evolution, in how legal systems are adapting to it. And we fear, or we get the idea that, at least for the present time, they feel like those are pilot experiences that we are just using for low intensity cases. So at the moment, most legal systems are dealing with a generalization of remote hearings and the experiences of online courts, completely dematerialized proceedings, only for low value issues, only for low intensity cases, which gives us a hint that somehow lawmakers have the feeling that it's not the same being completely digital as being traditional. This being said, I will give the floor to my other colleagues, starting with Erahan.
Good morning, everyone. I am Erahan at Sungkyunkwan University, Seoul, and this is my teaching voice. And my chapter focuses on the digitization of rather day-to-day functions of civil proceedings, that is digital case management systems, e-filing and e-service, and e-enforcement. I know everybody loves AI, but my chapter doesn't deal with AI too much. I have gathered and compared various judiciary's endeavors on these issues, but in this presentation, I would like to emphasize key findings rather than explaining all the minute details, which is described in my writing. Digital case management systems, or CMS, have been continuously developed and enhanced since their initial implementation. They have become integral as a digital judicial hub, incorporating various digital tools such as judicial support tools, e-filing and e-service tools and access to justice tools, as well as the original internal CMS. As CMS have evolved into a more comprehensive one-stop shop, efficiency, transparency, and access to justice have significantly improved. However, CMS pose various risks and challenges as well. System stability, security, and accuracy of the input data are the most basic requirements of CMS, but lots of efforts should be devoted to achieving these seemingly simple goals. Furthermore, even a well-functioning CMS can potentially undermine procedural justice by prioritizing quantity of the judge's performance over quality of the procedure and outcome, which happens in Korea and other countries as well. And especially the use of AI at various stages of judicial proceedings, from automatic case triage to AI assistance for judges and judicial chatbots, which is now quite vigorously discussed as we have now the generative AI, might undermine judicial independence and individualized justice, and would also require the right balance between the convenience and accuracy and data protection and open justice. Above all, digital transformation can never stop, as better technologies emerge every day and users' demands to the systems change accordingly. However, examples of various judiciary success and failure stories in digitization show how difficult it is to constantly adapt to a rapidly changing digital environment. Here, how various factors have caused different results in the real world are compared and analyzed. Now, e-filing and e-service are legal actions with direct legal effects on civil procedures and outcomes. Fundamental judicial principles such as the rule of law, judicial independence, fair trial, non-discrimination, and access to an effective judicial remedy must be central to their implementation. Initially, e-filing and e-service were limited to a selected group of legal professionals with specialized devices that can guarantee their identity. Gradually, e-filing and e-service have integrated to a single e-platform, where we all love platforms now, accessible to a wider user groups thanks to advancement in e-identity, e-authentication, and e-signature tools, along with relevant legislative developments, national and EU level, and budget allocations and continuous judicial initiatives. Expanding the subjective and objective scope of judicial e-platform and ensuring equal access for non-users will remain the key objectives of digital transformation and the ongoing responsibility of the judiciary. Additionally, the efficiency, economy, and access to justice can be achieved through e-filing and e-service in cross-border litigation, as demonstrated by the EU's recent experiences and recent legislations, which underscores the need for amendments to the Hague Service Convention, which is quite outdated. It was born before I was born, or the development of new instruments to facilitate international electronic judicial cooperation. And finally, digital technologies in enforcement proceedings include e-filing and e-service of enforcement documents, electronic search and tracing of debtors' assets, automatic seizure and automatic enforcement, and e-auction platform, among others. The distributed authorities among the court's enforcement officers or bailiffs, and sometimes private enforcement agents, and diverse and conflicting interests of judgment creditors, debtors, bidders, and other stakeholders make the implementation of e-enforcement more difficult than that of main civil proceedings. various enforcement authorities might not share the same view on e-enforcement, which is delaying the South Korea's adoption of e-auction, actually. And while digitization facilitates tracing and seizing of debtors' assets, it can also lead to an excessive invasion to the debtor's privacy and livelihoods in the absence of appropriate safeguards. Previous procedural protections sufficing for traditional situations may not be enough when almost every financial activity of the debtor can be traced electronically. Completely untraceable digital assets such as cryptocurrencies stored in a cold wallet, which I don't have, are and will continue to be a conundrum to the effective collection of debts. E-auction, while praised for its swiftness, efficiency, transparency, and accessibility, makes it difficult to offer other neutral options to people isolated from IT. Proportionality and the reasonableness of cost must be taken into account when handling these issues. In conclusion, the tedious tasks of making a robust and stable system, protecting users' privacy, and improving digital literacy of users are more important than adopting the latest cutting-edge solutions. And it is crucial to keep the right pace in implementing digital technologies in judicial proceedings. Thank you.
Good morning, everybody. Some difficulties here. Putting the paper. Good morning, everybody. My name is Björn Laukermann. I'm a professor from the University of Tübingen, having spent here wonderful years at this very building, at the Institute and the Burkhard Hess. And I'm happy to present you something about the ADR topic and at its crossroads to AI. This might be a bit surprising that I focus a bit on the platform-based enforcement of rights, but this is the technically and normatively most dynamic and innovative part of AI in the context of this new development. So the chapter is dedicated to describe the exact role procedural law can play in the platform-based enforcement of rights and standards, and particularly to describe how over time procedural structures emerged and do more and more govern the multipolar relationship between rights holders, online platforms, users, and third parties. Relationships that initially were solely based on liability rules of private law. So we have really a development into procedural law. What aspects can be highlighted in particular? You see these 5 points. I will go quickly through them. The first issue is the economization of platform procedures. As you all know, platforms enforce as well state law as well as their own standards. They provide independent complaint procedures for arising disputes, usually in an easily accessible, cost and time-saving manner. In doing so, such disputes almost invariably no longer reach state courts. This absorption effect stems from the privatization of judicial, enforcement, and regulatory tasks by private actors. What is more, the business model tailored by platform to specific uses is often continued in an economization of internal platform procedures. Frequently, the result is a different treatment of user groups, be in terms of access to internal complaint procedures, be it with regard to the person or the technical medium designated by a platform for making the decision. As a result, the principle of equal treatment of parties and participants, which is derived from national law, is partly put into perspective. In this respect, the role of online platforms is advancing from mere mediators of sanctions to mediators of economic growth. Second, another line of development occurs in parallel, the merging of state and private enforcement interests, which proves to be problematic whenever online platforms do not separate the enforcement of state-granted rights on the one hand and their own private standards on the other. It is not uncommon for state authorities to resort to platforms in order to enforce the standards of those private actors without disclosing and justifying their actual public enforcement interests. By acting this way, state authorities run the risk of circumventing the rule of law. In addition, private platform standards are often interpreted in line with a specific pre-understanding or regulatory calculation of a state. As a consequence, the guiding function and recognizability of state law will be weakened. Compared to this, internal complaint procedures of platforms offer little effective protection, especially as online platforms do not yet provide any specific remedies against acts initiated by a state. And finally, by instrumentalizing large international online platforms, government agencies hope to enforce national law de facto with transnational effect, as can be illustrated by the global application of the fair use principle inherent in US copyright law. Third, the use of AI supports and reinforces such effects. In platform-based dispute resolution, it harbors the risk of opaque decision bases, all the so-called black box problem. Thus, AI regularly prevents individual steps in the decision-making process from being reconstructed. It is the independence of the output from the input, often in conjunction with feedback loops, that favors the phenomenon of algorithmic discrimination. On the one hand, rapid technical progress offers the possibility of ever greater flexibility and individualization of platform procedures. On the other, AI is technically, as you all know, incapable of making cognitive, judgment-based or value-related decisions. The same applies to the lacking ability to grasp highly context-sensitive content in a legally correct manner. In addition, AI's strict reference to the past makes it impossible to develop the law in individual cases. All of these potential consequences considerably affect the effective legal defense of both platform users and rights holders. Fourth, proceduralization. To such dangers, an increased proceduralization of private rights and standards enforcement offers a solution. The aim is to enable the adequacy of enforcement, but also effective rights holders, to effectively realize their rights and thus to provisionally balance their rights in a context of uncertain legal and factual situation in a less faulty manner. Recently, state regulatory acts have taken a first corresponding approach. The European Union's Digital Services Act serves as an inspiration. Hereby, procedural minimum standards, especially borrowed from the guarantees of state procedure, are being put in place. These include, inter alia, the right to equal access to proceedings, the obligation of a platform operator to justify decisions, as well as the right to an effective complaint. In the interests of platform users, these rights particularly aim to guarantee the right to be heard and effective legal defense, and therefore reconcile power and information imbalances within platform structures. Above this, a multipolar, more differentiated conflict resolution system is emerging that does not only include online platforms, rights holders and users, but also third parties such as whistleblowers. Nevertheless, there's still a need for further regulation. For instance, and above all, the objective for more closely dovetailing the platform's internal complaint procedures with procedures for independent out-of-court dispute resolution. It has not yet been sufficiently implemented. This applies all the more in the light of a structural bias of platforms, especially when enforcing their own standards. To date, some improvements of the existing regulation should be done to avoid distortion effects. These distortion effects are particularly associated with context-sensitive disputes and have often a transnational reach. Such protection is, amongst other things, promised by increased transparency obligations. They are a key component of proceduralization. And transparency becomes, therefore, really a central principle of platform-based law enforcement. My last point refers to the regulatory dimension, because it can be observed a kind of standardization of platform-based rule enforcement. This is the result of feedback from individual platform decisions to a platform's AI system. At the same time, an ongoing implementation of platform-specific standards influences their dynamic regulatory development. This, I called it collectivizing effect, is reinforced by so-called platform courts. That means non-governmental, court-like dispute resolution bodies, such as the Facebook Oversight Board. Such courts will not only have the task of settling individual disputes and continuously harmonizing decision-making and interpretation of a platform's community standards. Platform courts at once shape a private process of rule setting, especially following a procedural concept of self-regulation. This process of norm building is partly beyond state control of the framework conditions, while at the same time being communicatively tied back to the public. Such a concentration in this way, interpretation, setting and enforcement of private standards amalgamate into one power. So we're three powers amalgamating to one power of the platform. Such a concentration of power of online courts can be counted from the perspective of various fields of law, of competition law, etc. As far as procedural law is concerned, out-of-court dispute settlement opens up an incentive check of the platform's terms and conditions under the laws, state laws, and the regulations of the European Union. And this indirect control can be flanked by opportunities, of course, of a state to directly regulate an internal platform procedure, which finds its paradigmatic expression in the Digital Services Act. Thank you very much.
Good morning, everybody. My name is Paolo Comoglio, and also this is my teaching voice. It's not so good. I'm professor of civil procedure from the University of Genova in Italy. And I would like to thank the organizers of this truly inspiring project. And also I would like to thank Professor Fernando Gascon for inviting me and my colleagues in this segment. I have strange feelings about this conference. First of all, I'm sad, obviously, because the project is ending. At the same time, I'm also happy because I'm going to finish my chapter. I would say I'm going to abandon it. Indeed, it's impossible to finish a chapter about the relationship between new technologies and legal professions. Every month, I may say every day, there is always something new and increasingly challenging to consider. But also have another feeling. A few years ago, when I was practicing law, one of my clients' company asked me to supervise the interviews for the selection of its first in-house counsel. Of course, I did my job. However, I was fully aware that I would lose my client. The company would certainly have asked the in-house counsel instead of me. It would have been clever and cheaper. And so it happened, obviously. Today, I have the exact same feeling with generative AI, generative artificial intelligence, the latest hot topic in new technologies. I have already wasted too much time. Let us come to the topics of my chapter. Last year, during the midterm conference, I said that I would ask questions about the relationship between technology and legal profession, but that I would not be able to give answers. I have kept my promises. Actually, I have no answers, In fact, I have even more questions, as you see in this presentation. Obviously, I have little time and cannot deal with all of these topics. I would like to share some brief thoughts with you precisely about the impact of generative AI on the legal professions and consequently on the access to justice. Actually, this problem is not new. Technologies have always influenced law and legal professions. However, today's new technologies are different from previous ones. Until today, the role of the lawyers has always been to make the law accessible to those who lack the technical knowledge to understand it. The internet has made much legal information available to all. Despite this, the internet has not weakened the role of the lawyer. However, generative AI is different. Generative AI can answer in common language, can be easily used by everyone, and at the end is able to answer legal questions and to give legal advice, even without the assistance of a lawyer. We can assume that actually generative AI can compete with lawyers by offering out-of-court legal advice, perhaps even using our chapters of CPLJ, as my colleague Eran told us yesterday. One might wonder whether the legal services provided by generative AI can be considered as unauthorized practice of law and therefore prohibited. I think this is not possible. First of all, it's difficult to understand what practice of law out of court means. Almost everywhere in the world, the law reserves legal advice to lawyers without defining, however, what is meant by legal advice. Secondly, the use of unauthorized practice of law rules may not be socially accepted. In fact, this kind of prosecution frequently seems to be motivated by self-interest of the advocacy. So then the question is whether tailor-made regulation is needed. For example, the EU regulation on artificial intelligence does not seem to take this situation into account. Indeed, the EU regulation does not consider the use of artificial intelligence for legal advice as a high-risk activity. In fact, according to this regulation, tools offering AI-based legal advice do not seem to fall within a high-risk sector. In particular, the regulation considers high-risk only AI systems intended to assist judicial authorities, thus implicitly excluding from the scope of application tool used outside judicial activity. This approach does not seem acceptable and can have a very negative impact on access to justice. Consider, for example, a person who gets advice from an AI-based tool and relying solely on the advice provided by this tool decides not to sue someone. It seems frankly difficult to imagine that such use of an AI tool potentially discouraging the access to justice is not high risk. Nor should we forget the potential conflicts of interest that could arise between the owner of the legal advice tool and the users. We can assume a generative AI tool for legal advice owned by a company that also offers other services to consumers. There is obviously a risk that the legal advice offered is aimed at discouraging potential legal action against such a service provider. In addition, in the absence of regulation, this risk may increase as a result of the fact that predictive algorithms will almost certainly end up in the hands of a very few big corporations. Even leaving aside the problem of conflict of interest, there is a risk that algorithms offering and providing legal advice are not reliable. These unreliable algorithms could affect not only the users, as I said, but also lawyers and judges. Often, lawyers and judges are lazy, as I am. It could happen that they might still be tempted to secretly use such algorithms, such unreliable algorithms, to simplify their job, even if they are not allowed to do so. For this reason, therefore, it seems to me unavoidable to impose by laws specific reliability and transparency requirements for generative AI tools offering legal advice out of court. Last year, in the midterm conference, I concluded my presentation wishing to all of us have your AI in court, assuming that in the short term, AI will severely affect judicial proceedings. Today, taking into account the explosion of generative AI, the issue is much broader, and I might conclude wishing have your AI out of court. Thank you for your patience. Thanks.
Thank you very much. I'm sure we will have plenty of questions, but we don't have so much time that please. Yes.
I have a question to the whole team, because Fernando said we are not so happy with the idea, the digital revolution as a title. When I read your papers a little informally, I said to myself, yes, this was a good idea. Call it a revolution. So do we have a disruptive moment here or not? I think, of course, lawyers, jurists tend to be not disruptive. Yeah. But the development is driven not only by the law, but by technology. And what we have heard, especially in the two last presentations, goes more in the sense of a revolution, I would say. I would also take up your e-management. And I don't know, I haven't read your paper when you spoke. I was very much amazed by the Uniform Patent Court that has started in Europe and which has really developed in a very quick way. By the way, the appeal chamber is located not far from here in Luxembourg. And they started 1 year ago. They have more than 400 cases since the start. Parties are not obliged to choose the system, but they do. And there we can see how management, electronic management on a platform is able to operate even at different levels. So you get immediately an appeal, the file is open to the appellate chamber, they can decide immediately and it goes very quickly. So maybe this is a phenomenon which demonstrates to where we are heading to.
Do we? Yes.
Stefan Huber, University of Tübingen. Thank you very much for these presentations. And you all mentioned the keyword transparency. I think transparency is very important in this context of AI. Could you maybe explicit a little bit more what degree of transparency you would require, what degree is already achieved, what you could imagine, under which conditions you could imagine using AI for ADR or for the state court system? Additional that.
I may start with ADIs, ADR. I skipped this issue. I wanted to point out some concrete obligations of transparency. Transparency has a twofold function. The first function is an institutional function. So under the DSA, platforms have the duty to give in forms of transparency reports an insight of the cases they dealt with, insofar as they have to mention how many cases have been brought to the platform, in what way the platform has decided, etc. So a very fine-grained transparency obligation in terms of these annual reports. This is the institutional effect which offers control by the public vis-a-vis the platforms. The other transparency obligation is an obligation towards the individual user. This is an auxiliary function in individual proceedings. So this is a classical procedural principle in terms that a platform has vis-a-vis the users on the basis of its terms and conditions, say whether it uses AI, which form of AI, and has to say what kind of procedural remedies are offered in terms of, is there a counterbalance mechanism, what time frames will apply. So they're very fine-grained obligations in order to foster the right to be heard and in order to concretize the whole procedural systems. So this is a very fine-grained twofold system.
Yeah, Supreme Court. I have a question to Pio. if I understood you correctly, at certain point you said the platform are becoming from a mediator of sanctions to mediator of economic growth. This is a very interesting point. Can you give us some details?
So the actual idea was at the very beginning that platforms work as a kind of mediators. Some authors in the US said they become a kind of judge because they, and even the German court of the federal court implemented a kind of shuttle system that meant that we have a three-party constellation. We have rights holders, we have users of a platform, and we have the platform itself. The platform is a kind of mediator in the sense that the right holder notices there's an alleged infringement of his, let's say, patent right, and then the platform has the obligation of a mediator to transform the notice to the respective user, to the alleged infringer of the right, and to give him the right to be heard, and then the submission of the user has to be transmitted again to the right holder. And there was the first moment of a kind of a proceduralization as a mediator giving the right to be heard to the two parties of this dispute. So this is a classical mediation role which was at the beginning of the emergence of a procedural structure. But at the same time, online platforms have purely economic own interests. And these own interests manifest also in very concrete economic relationships with particular users, with particular right holders on the basis of contractual agreements, which gives them a better treatment in respect to other right holders, which gives other users, state courts, prominence, big companies, a preferential treatment vis-a-vis other users. So, and this is extended into a procedural system. So that means that the right to a human review is only given for content review mechanism at Facebook for particular prominent users, while for ordinary users, there's an algorithmic approach, at first sight at least. So we have a different treatment in procedural matters as regards who is taking the decision, who has access to a complaint procedure, and as well, who gives notices of infringements of rights. So they're privileged whistleblowers, they're kind of referral units where you have certified notice givers, and they are treated preferentially. So once, let's say, a state authority gives a notice that a certain right has been infringed, the platform is not counter-checking whether this is correct or not, or whether this is obvious or not. Yeah. It just takes down a certain mechanism. And this is a very interesting phenomenon. So in that context, we have a shift really to a mixture of a kind of mediator role and a role of a person who has clearly own interest and is structurally biased.
Thank you.
So that's why I have made the point in my chapter to say we should not accept online platforms to be judges or to be put into the role of a court judge, because online platforms do not have neither the power to act like a judge, nor are they structurally in a position to act like a judge.
We have one question, it would be the last question.
I cannot do it if we're out of time.
No, please.
Well, Scott Dodson, the public courts are geared and very tightly controlled to pursue the goals that the public courts are designed to pursue, right? So you've got justice and access to justice and efficiency and dispute resolution and law pronouncement, and these are tightly controlled and managed goals that are essential for a public court function. But public courts are kind of bad at technology, and so as a result, I think we see courts outsourcing a little, using vendors, private markets to incorporate the technology for the needs of the court in an evolving society, right? But does that tend then to diminish or degrade the control that the public courts have over their own operations and therefore over the protection of their own goals? Are we threatening? Are we having kind of a hybrid public, almost private court system, and should we worry then about those goals and those values being hijacked perhaps by private interests, by large companies that manage the software, that have their own interests? Are those concerns that we ought to be worried about?
I would say so. Because our judges are not, and our lawyers are not technically qualified to really understand how the system functions. So whenever you go to the court system and it is electronically based, you will find the court officers saying, well, I'm sorry, I cannot upload this kind of document because the system does not allow me to do it. And of course, you cannot expect from a court officer to circumvent the circumstance because he or she they're not technicians. And then you have to call the company providing the service. Yes, 1,000 euros if you want to adapt the system in order to be able to adapt to this new need, which was undetected so far. And that's the way it goes. But I believe, I'm experiencing this in university administration. It happens everywhere where you are a user of technology which is not created by you. And of course, we cannot expect court officers to be at the same time IT persons, because such people do not exist so far. And and now that I have the flow for a second workout, when I said evolution, revolution, I was not saying the title you chose was incorrect. Of course, never. No. No, but what I'm saying is that there is a constant evolution in the digital revolution. Okay, so that was my point. If we had finished 2 years ago, a ChatGPT, Gemini, and so on would have been out of discussion. And now they're part of one of the most interesting developments. The same with some internet courts that are emerging in the other side of the globe, and the same with many of our chapters. So the idea is, well, the revolution is disruptive, but it did not happen at once. As always in history with revolutions, they evolve in time, and this has caught us in the middle of the evolution. So we beg for your understanding. If you open our chapters next year and you laugh at us and at how naive we were or how tremendous we were in our assertions, because probably with perspective, things will be regarded differently.
So you should read it first.
Thank you very much. Another ongoing revolution or evolution.
Yes, of course.
Please. And if I may, it's 30 minutes with discussion, so if we can keep it short, it would be wonderful.
We'll do our best.
Thank you very much. So I'm very pleased to welcome the collective litigation segment team. We will start with Professor Teresa Arruda Alvim from the Catholic.
Actually, we are.
She'll be the first. Okay, sorry. So on my program it was Teresa first, but Elisabetta, you will start from the University of Pavia in Italy, and then Teresa from the University of Sao Paulo, and Stefan Booth from Cairo Leuven. I would say a good word. The floor is yours. Thank you very much.
Thank you. Good morning, everyone. It's good to see you all this morning, though I suppose that many of you, after yesterday's marathon, crowned by a very good dinner, would have preferred to sleep in a little bit. Before we dive into part 10 on collective litigation, of course, I want to thank the directors of the projects, the Luxembourg team and the Vienna team, and all those who contributed to the organization of this event. But most of all, I really want to thank all the active members of our group. Actually, I should say all the surviving members of our group, since we lost some group members along the way. Of course, you see next to me Teresa, Stefan. Two members could not make it, and they are Theo Broderick from South Africa and Deborah Hensler from the United States. Additionally, I would like to mention some particular features of Part 10. We have not prepared any slides in order to be good and keep up with the schedule, so forgive us if we didn't do that. Talking about this particular feature of Part 10, you will notice when you read our contribution on the website that at the beginning there are a few brief notes that I wrote, and they are simply intended to set the scene, and they act as a prologue, if you will. This is followed by the introductory chapter authored by our team leader, Teresa. In the writing of the chapter, each member of our team was equally involved and equally committed to the success of our project. To that end, we deemed it appropriate to give everyone an equal opportunity to express his or her own ideas on the topic addressed, if they wish to do so. This is demonstrated by the presence of different conclusions by Teresa, Deborah, Theo, and myself at the end of Part 10. I turn now to the body of our work. In her introductory chapter, Teresa explains how the rise of mass societies and the recognitions of rights pertaining to large numbers of individuals, if not to the entire human community, brought about the awareness that the traditional tool for judicial protection and enforcement of these very rights, meaning individual litigation, would no longer work as desired. Teresa describes in detail the emergence of collective litigation, using this expression in a very wide sense, and emphasizes how the accepted category of the law of civil procedure, conceived to fit individual litigation, had to be abandoned or modified with a view to devising novel procedural frameworks able to bring justice to many individuals identically or similarly harmed and in need of regaining the full enjoyment of their infringed rights. Joinder of claims, known to the majority of legal systems, proved to be largely ineffective, Teresa observes, which prompted the development of collective litigation in its two main patterns: representative actions and aggregate litigation. Chapters 2 and 3 deal extensively with the representative actions, analyzing the common law model, meaning the US class actions, and the variation on the theme of class actions adopted by other countries belonging to the same legal tradition, vis-à-vis the civil law model, a model that, like class actions, knows several variations in the identification of the special purpose vehicle, so to speak, as the preferred representative of the class. Chapter 3, in particular, addresses a variety of issues that are common to all types of representative actions, such as the role of the judge, the role of lawyers, the binding force of settlement, and funding, which seems to be one of the main issues in this matter. Chapter 4 is devoted to aggregate litigation, highlighting its main differences from representative actions and describing various types of aggregative mechanisms adopted around the world. Chapter 5 addresses the topic of other devices that have been put in place to handle mass claims, specifically arbitration, ADR, and the so-called regulatory redress. I wish to conclude by saying that participating in this project was an enriching experience for me personally, and I believe all of the members of our team, at least the surviving one, will agree with me when I say that it helped us grow in our knowledge of comparative civil procedure. And now I give the floor to Stefan.
Okay, thank you very much. Ladies and gentlemen, I will be a porte-parole today. One of our group members is Professor Deborah Hensler, who I think in the field of collective redress does not need a lot of introduction. Unfortunately, Deborah could not be here today, but she sent us some thoughts, and we have agreed that I will share these thoughts with you. So now you have to pretend that I am Deborah. I'm very sorry I cannot be in Luxembourg with you to discuss and celebrate the work of the CPLJ. In my absence, I have asked colleagues on segment 10 to share a few thoughts with you. It has been a wonderful experience collaborating with and learning from colleagues on the project, including old friends like Elisabetta, Stefan, and Theo, and new friends like Teresa. From them, I have learned much about the procedural law and the evolution of collective litigation procedures in Brazil, Europe, especially Belgium and Italy, and South Africa. But perhaps more importantly, I have learned something about the delights and pitfalls of comparative legal analysis. In these brief comments, I want to share my perspective on two types of pitfalls. First, when conducting comparative analysis, we all bring strength in the form of our knowledge of our own legal regime's statutes, rules, and practices. But we all also suffer weakness in our knowledge of each other's jurisdictions' legal regimes, even as we try to overcome that weakness by reading relevant literature and interacting with colleagues. Our team benefited from having decided at the outset to write our contribution in a truly collaborative fashion, so that most of our individual chapters were co-authored by legal scholars from different jurisdictions and cultures, and the sections referencing different jurisdictions were mainly written by those of us with expertise about those jurisdictions. However, because of the historical prominence of US procedural law in the domain of collective litigation, it was often the case that my international colleagues would write about US procedure and practice in the course of comparing their own regimes to the American model. When doing so, they would rely on relevant US literature, but also on their own understandings of the American model, based frequently on their participation in public policy debates on the adoption of collective litigation procedures in Europe or Latin America. To the extent that the literature my colleagues relied on referenced procedural rules, statutes, and court decisions, being excellent scholars, their descriptions were correct. However, when they wrote about practice, who files class actions, and for what purposes or consequences, the impact of class actions on class members and defendants, both empirical rather than theoretical or normative matters, my colleagues often fell back on the unexamined and unsubstantiated tropes about American-style class actions that permeate policy debates about collective litigation outside the US. That these oft-repeated assertions about frivolous litigation, abuses, blackmail settlements, and the like are not supported by empirical evidence, have been injected into the public policy debate by self-interested corporate lobbyists, usually went unnoticed. Although I sometimes felt frustrated by the long-enduring nature of these assertions, I could scarcely blame my colleagues because much of the American legal literature on class actions similarly repeats these assertions without attention to their validity or invalidity. As I think those on my team all believe, the introduction of collective litigation procedures into all of our legal regimes can have profound consequences for due process and fairness, as well as efficiency. It is important that we support evidence-based analysis of these consequences rather than simply repeating old tropes. Although not all legal scholars are policy analysts, it is important when writing about legal rules that may have profound consequences for economy and society, that we ask whether there is evidence to support scholarly assertions. By working together, I think our team ultimately was able to do better on this dimension than is often true of other comparative legal analysis. Second, a less value-laden pitfall of comparative legal procedure analysis is our tendency to impose the structure of our own procedures on the procedures of other legal regimes in a way that leads to inaccurate portrayals of those other procedures. For example, when describing the role of class members in US class actions in an early draft of one section, one colleague referred to plaintiff organizations. As many of you know, in US class actions, one or few representative plaintiffs assert claims on behalf of dispersed class members. An analyst knowledgeable about the European model of qualified entities might justifiably assume that some sort of organization must be at play in common law actions as well without realizing this is inaccurate. Similarly, when writing about aggregate non-class actions, I had to be careful and check myself when discussing the German Kappbuch and the English GLO, lest I inappropriately import my own understanding of US multi-district litigation practice, another form of non-class aggregate litigation. In sum, comparative procedural law analysis is a fascinating and enriching scholarly activity. There is much we can learn from each other, as I did from this experience. However, we all need to be careful about imposing assumptions colored by our own regime's rules and practices on our analysis of other jurisdictions' law and practice. And given the profound policy consequences of introducing collective procedures into contemporary legal regimes, we need to avoid easy acceptance of unsupported assertions about how these regimes work in practice, and we should lead the way in calling for careful empirical analysis of their consequences. Thank you.
Well, good morning. Thank you for being here. First of all, despite despite the fact that I have just a few minutes to talk, I would really like to thank our coordinators for the invitation to participate in this wonderful, interesting, and mainly generous project. And also I'd like to thank the surviving members, very good friends, Elisabetta and Stefan, and also Deborah and Theo. Well, I will now say a few words, just a few words, about what I think the future of collective litigation will be. As we all know, collective litigation has the potential to change behaviors. This is precisely the characteristic in its strongest version that's going to prevail in the near future. I think, it's my opinion. When a tool of collective litigation is used to provoke changes in society at a structural or regulatory level, we can say that this is used in a strategic way. This happens when the plaintiff aims for much more than a favorable award. There are many examples of tools of collective litigation, mainly those considered according to some criteria, genuine class actions that generated significant changes in society. I dare to say it happens more frequently in developing countries. It's very important to stress that not only class actions or any other tool of collective litigation are able to play this strategic role, but it's natural that class actions do that more frequently than individual ones. And this is because strategic litigation normally involves consumer rights, climate change, fundamental rights, etc., which are much more efficiently protected by class actions. Some examples from different countries, namely Costa Rica, India, Argentina, and Brazil, will be given to illustrate this. There's a good example of strategic litigation in Costa Rica, where the Constitutional Chamber of the Supreme Court of Justice ruled on the right to health care in a case related to the AIDS epidemic in the 90s. India. The case law of the Indian Supreme Court is highly relevant with regard to social rights. Commentators say that this is one of the most powerful constitutional courts in the world. The instruments that they have, PIL, public interest litigation, and CEL, social action litigation, are considered class actions, and they ensure results with a great impact on many of the country's internal structures. In Argentina, one of the most prominent class actions was filed by a group of residents affected by the high levels of pollution of the Manzana-Riachuelo rivers. It led to a decision determining that the government should prepare a restructuring plan to combat pollution and submit follow-up reports on its compliance with the ruling. This is a wonderful example of how class actions may play this strategic role with structural results. In Brazil, we have witnessed several environment disasters. Brumadinho in 2019 is maybe the best and the worst example of lawsuits with structural results. It was an enormous tragedy. Some municipalities were completely destroyed, devastated really. It occurred when a tailings dam burst and millions of cubic meters of mining waste were dumped into some rivers, causing deaths as well as medium and long-term consequences. Crimes against fauna and flora were committed. A huge number of individual suits and class actions were filed. A settlement was reached, and precisely under the terms of this settlement, a structural effect was observed. Besides the compensation for damages caused by the accident, the defendants undertook the task of developing the region by giving professional training to young people, by creating and supporting entities that assist women who are victims of domestic violence, and also creating these entities to support those who are addicted to alcohol and drugs, as well as building multi-sports courts and so on. The settlement obviously goes far beyond just compensating the losses by encompassing measures that aim to really restructure the region that was totally destroyed by the accident. Well, the fact that a company gets an adverse judgment may have an impact on the conduct of other companies, as well as influence legislators' disposition to create new statutes. And there's a good example in Brazil. In 2019, a class action was filed against British American Tobacco, Philip Morris, and Souza Cruz, where a claim was made to compensate the government for expenses incurred with the treatment of various types of cancer, tuberculosis, pneumonia, among others, either caused or aggravated by the consumption of cigarettes or by exposure to cigarette smoke. This class action led to the issuing of a decree which established a task force to discuss an increase in the taxation of cigarettes. The pressure exerted by class actions like this led companies to explicitly warn consumers on the cigarette packet that the product can cause cancer and other diseases. Allow me to conclude. This approach may surprise conservative scholars because to a certain extent it implies that judges should do what they are not meant to do, at least according to the original concept of the separation of powers. Furthermore, rendering decisions for the future is not the typical work of courts. In fact, normal litigation is retrospective. Judges look backwards at the pre-existing law, at facts, at how they happened, etc. On the other hand, strategic litigation is forward-looking. It brings consequences that unfold over time. Such decisions, in my opinion, can directly or indirectly contribute to improve a country's quality of life. Thank you very much. Thank you very much.
Thank you very much indeed. And I think with the topic of special subject matter this afternoon, we will have similar question or comments. And thank you for this insight, not only on collective litigation, but also on the challenges of comparative civil procedure into taking in account the practice, but also the political and economic context. And I'm not surprised that you already raised your hands.
If I may, Rick.
Yeah, sure.
Footnote to Deborah's piece. 8 years ago, the Presidium back here in Burkhardt came up to me and said, "What can you tell me about Judge Breyer?" Why? Because the VW diesel cases, multi-district litigation, were pending before Judge Breyer. Breyer bought Monsanto, and multi-district litigation involving Roundup, something people use in their gardens, it makes that purchase decision look unwise in retrospect. The point being, news, we will probably at the end of next year have a new federal rule of civil procedure about multi-district litigation, which is the product of 7 years' work that included many assertions of the sort Deborah described. Anybody who's interested, I'll go into detail, but that's the other big ball game in our town. And if you think of Bayer and VW and others, it may be coming to your town also.
Dolly noted.
Are there any comments or questions? No. So we can turn and we will be on time. So we can turn, and thank you very much again. And we can turn to special forms of litigation. Please come. So it's my pleasure to please. Yeah, if you want to speak everything is possible, but the important thing is that you can stick to the time, because it's not 30 minutes plus, it's really 30 minutes with discussion. So dear colleagues, it's my pleasure to welcome, maybe I will let you present yourself. It will be easier because I don't know, well, I know that Fernanda will speak first now, but I don't know after all. So please present yourself and the floor is yours.
Okay, good morning. My name is Fernanda Pantoja. I'm from Rio de Janeiro, from Pontifical University, Catholic University, PUC-Rio. I must say really fast that it's a huge pleasure to be part of this outstanding project and to be part of this group. As you can see, only part of the group is here. Everybody survived, but some couldn't attend the conference. So Soraya, who is our careful coordinator, is not here, and Mary Ellen and no, they're not here.
You don't have your presentation.
Yes.
Oh, we don't have.
Okay, so and Mary Ellen and UN are not here, but each one of us will handle a topic of the segment so that we can give you a big picture of it. We may establish 3 premises based in our study. The first premise is that there is not an autonomous category of special forms of procedure. This is why it's so hard to define it, because it comprehends many types of different procedures. Some procedures could be classified as special, but they weren't part of our study. So, for example, special subject matters, arbitration procedures, enforcement procedures, collective actions, they were excluded from our part. So this segment deals with 3 types of special forms of procedure. First, provisional and protective measures. Second, payment order and default proceedings. And third, summary procedures, including small claims. The second premise is that these procedures, they have all the same aim, which is to seek the efficiency for both litigants and the justice system. So what makes them special is that they bend the ordinary rules to ensure the effective access to justice. And that's why we added a subtitle to our segment, which is special forms of litigation, prioritizing the efficiency of judicial systems. To meet the need for efficiency, they have simplified and streamlined rules, but they are very different from each other, as you know, because they do not have exactly the same objectives. So efficiency, when you talk about provisional measures, means preserving the efficacy of current or future proceedings. When you talk about payment order or default procedures, it means enhancing the rapid recovery of debts or recognizing rights. And in the case of summary procedures, it means managing a large volume of litigation. The third premise is that this variety of forms, or we could say the sophistication of special forms of procedures, is a sign of maturity and of development of procedural systems. And this diversification concerns their sources, their methods, and their applications. For example, they may be created by law, which is usually the more usual form. They can be originated from the practice, such as the guide issued by International Chamber of Commerce in Paris, and even by contract. The cognitive clauses are contractual clauses that can create different procedures in the United States. Special forms can be integrated into ordinary proceedings or can be autonomous. They are sometimes mandatory, such as small claims, but they may also be optional. And they usually have many other particular features like special jurisdictional rules, different legal representations, reduced time limits, limitation of the issues that can be raised in defense and of the evidence that may be produced by the parties, limitation of the judge's power to evaluate evidence, absence of res judicata, special appeal rules, encouragement to settle, use of technology. The problem, finishing, is that these features designed to achieve efficiency, they may have a perverse effect if they lead to undue restrictions on fundamental rights. The right to receive notice of the lawsuit, the right to be heard by a judge, to have a lawyer, to have a final and stable decision on the merits, to have a fair trial. And this is the main issue and the big challenge that arise from special forms of procedure, and we address it in our segment. The balance between effectiveness and the fairness of the procedures.
Good morning. Yeah, we had a PowerPoint, so we're all lost now. There was a sort of logical sequence of discussion, but it doesn't matter. We continue. The first part of our chapter focuses on provisional protective measures. And also, we had already finished it. I finished this part together with Guillermo already early last year. So there's not so much new compared to what we had already presented last year. What we did is to distinguish what what types of, or what sort of categories of professional measures are out there, which were nicely, of course, displayed on the screen. So these are the category of protective measures, evidence measures that Guillermo has worked on a lot, and a general provisional measures scheme consisting of regulatory measures and interim payments. What we have seen that, of course, there's a huge variety of provisional protective measures out there, though the main categories such as evidentiary measures or some type of regulatory measures, and of course preservative measures like attachment orders, are present in basically all systems. We have looked at the aims of the specific measures, the objectives, and also looking at fundamental rights protection, sort of the risks and benefits of these rules. And of course, we all know that provisional measures are essential to keep the system running, because otherwise you will lose rights. There may be irreparable damage if certain issues are not well addressed, or evidence might disappear, goods might disappear. So these are essential to keep the system running. How far we go in provisional measures differs a bit per country. And that also depends on the system as a whole. So looking at all the special procedures that we've looked at, for instance, my home jurisdiction doesn't have a dedicated procedure for the order for payment. There is a default procedure, but not a dedicated order for payment procedure. But then, apart from the European one, which is obligatory, but only for cross-border cases. But what we do have is interim payments. And the interim payments then in function take over part of what perhaps the order for payment means in other countries. So looking at the legal system as a whole and the variety of special procedures, then the differences might not be so big, but in the individual provisional measures and other procedures, there are quite big differences. What is very important in provisional measures is, so they are a very important weapon and instrument to secure enforcement of rights, but proportionality is also crucial there, because there will always be less full-fledged procedure or hardly any procedure in very urgent measures. And of course, then you have to sort of balance the rights of the claimant and the defendant. And that is also where Guillermo, I think, will jump in when it goes wrong about the liability, right?
Yes.
Yeah.
I always would like to address very specific points after the outstanding presentation of Fernanda and Sandra, which is the liability arising from the lefting aside the measures when the claim has been dropped, when the plaintiff has lost the case in the merits, in other cases. I think it's a crucial question in all the regime of the provisional measures, because it has to do, is closely related to the cases of the adopting the measures ex parte without previous hearing of the opposing party, and it has to do also with those vigorous, strong measures anticipating the final outcome of the proceeding. And there is a great variety of approaches in this field in the different jurisdictions. Most of them don't provide explicit provisions about what kind of responsibility, fault-based responsibility or strict liability. Few of them provide for strict liability. Other don't provide anything, but on case law basis have been decided that strict liability is in place. There is a great variety. But I think it's very important because with the strict liability system, judges, courts are more encouraged to take these outcome anticipating measures or to take measures without previous hearing of the parties. And otherwise, this is a case of Spain, for instance, they are rather reluctant to do it in this way. And this is a great variety of solutions given in the jurisdictions. And I think this is a very interesting issue to be addressed and comparative perspective. And I think it will be very interesting in a cross-border litigation also. I don't know if the people who has addressed this issue has been dealing with this question, but I think it is. And that's all.
Me?
Sorry. Yeah.
To speak loudly, I rather stand. I'm Vincent Richard. I worked at the Max Planck some years ago. Now I became a lawyer in Luxembourg. This is not my pleading voice because I learned that yelling at judges is very counterproductive. So I don't plead with this voice, but I'll try to reach the back of the room. I want first, of course, to thank the editor for conceiving this crazy idea and above all for implementing it. And to gather such a crowd here, it's really a very humbling and happy moment for me, and I guess for many people here. I want to thank also the member of the group, above all, perhaps Soraya Amrani-Meki, who is the coordinator of the group, although she cannot be here today, and also Fernanda, with whom I had the pleasure to write our chapter on default judgment and payment orders. Today, I'll speak for a few minutes only about payment orders, partly because I spoke last time about default judgment, so now I speak about payment orders, and partly because it embodies very well our chapter. It is undeniably a special form of procedure, and it is undeniably a procedure that favors efficiency, which is the subtitle we decided to adopt for the whole part. So the payment orders is a great procedure. It's a very simple one. It's a procedure where you have a debt, you send this request to the judge with your debt, with a bill, with an evidentiary document, and you have it approved by the judge, by a single judge who then notifies the debtor. The debtor either it doesn't contest, and then you get an enforceable title very quickly, or the debtor contests, and then you're back to ordinary procedures, with some caveats on what is ordinary procedures, but that is not the point here. So the French theorize it as being inversion du contentieux, which I had written on the slide so that you could write it down, but you have no slide, so you can't write it down. Inversion du contentieux, contentieux is litigation, dispute resolution. So it's a way to say we revert the dispute resolution. Instead of debating to get a consensual result, we decide first and we see who opposes. It's a very French concept. It works in legal environments. It works at the moment very well in politics. So first you decide, then you see who disagrees. It is so good that it became the model. The OADA is creating a uniform law for payment orders to implement it, to foster the implementation in African countries. And the EU has created a European payment order in 2006, this time to impose it in most European countries. So a very efficient procedure. But we can make it better. We can make it better for the claimant. Because for the claimant, we don't really need him to provide a bill. He can just make a sworn statement that there is a claim, that there is a debt. He can have just a simple description of the evidence. We can even make it better by making it more difficult for the defendant to oppose the claim, so that if his claim is unfounded, if his defense is unfounded, then he has to pay an additional penalty because he bothered the justice system with an unfounded defense. We can make it better by not having lawyers, so that as a claimant, you can stay in your office, in a nice bank, in a utility company, or even in a specialized debt recovery agency, and have your payment order in court without a lawyer. Because for simple matters, a lawyer is not efficient. Having a lawyer is not efficient. We can still make it better. We can make it better for the court, because then we don't really need a judge to do that. We can give it to a law clerk, and the law clerk can give a payment order without any reasoning in a few minutes. Because for simple matters like this, having a judge is not efficient. We can make it even better. Because now that the judge, who is not a judge, is just a law clerk, sometimes a notary, does a simple decision without a reasoning, then we can have a program doing it instead. We talk about AI, but here it's not an AI, it's a simple program that checks. Jurisdiction is checked, the claim is checked, then the enforcement title is issued. You don't need an AI to do that. Because for simple matters, involving a human is not necessarily efficient. So that is what you can do to do an efficient procedure, if that is what you want. Because maybe the picture I described is not necessarily the procedure we wish for. And in the introduction to our chapter, Soraya talks about the perverse effect of efficiency. Yesterday, I took that quote from Professor Margaret Hu, who said that legal procedure is not simply the practical way of ensuring the enforcement of substantive right efficiently, but legal procedure also reflects the collective sense of justice in a society. For payment orders here, you can see the efficient way of enforcing substantive rights, but the collective sense of justice that you should not dismiss it too quickly. So this is partly what our chapter is about. Of course, the monster I described does not exist in any jurisdiction, but I did not invent anything either. I just took the efficient characteristic of each. Of course, I remove completely, for the purpose of this presentation, any limits that judicial system impose, and there are limits. But this I leave you to read them in the chapter. All of this to say that if your only goal is efficiency, then you can create a monster like the one I've created, and it is, I think, the duty of lawyers or of academics to remind ourselves that efficiency is not the only parameters we should be using. And when you see our title, Prioritizing Efficiency, this is not a goal, this is a statement that is indeed criticized. But you can read all the details in our chapter, which is already online, if you want to. Thank you.
Sorry to be here again, but that is because indeed some of our members weren't there, and I will try to keep it short. I do mind the time. Our third chapter on content was on summary proceedings, which is also a whole variety of different procedures. And they have been categorized as provisional measures, also in 3 different parts. The most distinguished one is a small claims procedure that in different forms exists in all countries. Some by having a special dedicated court or having full online procedures as in England, and in others it's simply the lowest level of the court that deals with particular claims below a certain threshold. The second one is an early final judgment procedure that also takes shape in the different countries. And a third sort of residual category was an expedited trial procedures outside the small claim settings that does as such not exist in all countries. And that's also what I said when we talked about provisional measures, that there is there are a variety of different procedures, and you have to look at a legal system in the context of all these different procedures, because otherwise what may happen is indeed that you say, oh, but in that system they have this big monster, but if you look at the system as a whole, you see that there are checks and balances, or when one country goes a bit further in allowing interim payments, is because other types of procedures might not be there. So it is about balancing all these different types of procedures. I think also the summary proceedings as they are described in this third chapter are very important, of course, very dominantly for small claims procedures, where often the low value of the claim and often simplicity of the claim, though these go not necessarily together, don't justify a fully fledged complex procedures. That's not good for the cost side, but also, and that is what I value very highly, for parties that have a right to easy access to justice. And if it's a small consumer claim or another small claim, you should have simpler access to court, but of course also with the necessary boundaries and the necessary safeguards. So enabling access to justice, but avoiding risk is very important, because oral proceedings may be set aside, there may not be legal representation, etc. And that requires also a good and very active judge in those procedures. And then we come to our conclusion of the entire chapter, but the conclusion is also in the introduction. So the last part of the introduction written by Soraya functions as a conclusion for everyone, is based on the collective chapters. Vincent already mentioned the perverse effects of efficiency. That was the first bullet on our slide. we have to avoid government by numbers. So indeed, efficiency should not be the guiding rule. Everything has to be so efficient, because indeed there is a bigger need in the justice system to also really deliver justice and not to get rid of cases very quickly. And also it might be, if you don't outweigh proportionality and cost effectiveness well, that if you get rid of certain cases very quickly, that other cases get delayed, or that the system as a whole becomes at stake, because you don't overlook the whole picture and you're just focusing on getting rid of these minor or simple or special claims. Preserving fundamental rights is thus very important. These checks and balances are very important, especially the principle of orality, but also the need for representation, which is not always necessary, but in some cases it is necessary and will also lead to quality of justice, which is also very important. We have seen it in some systems. It is not even allowed to have legal representation for certain claims, and that is of course a huge limitation. We can imagine that there are certain systems, if you take a very expensive lawyer for a very simple claim, that maybe the cost shouldn't be reimbursed even if you win the claim, we understand that, but not to have the right to have a lawyer, as apparently exists in Korea, New Zealand, and we've read also in Quebec for certain cases, that is, and maybe a bit going in the wrong direction. These procedures, that the special procedures may, because there are so many, might actually be a main form of procedures, because, well, they are very high in number, the default claims, orders for payment, small claims, etc. And that is also why you have to look at the system as a whole, because their importance might change the concept of justice and also the role of the judge. And if the role of the judge, and then I also look at the first panel we had today, digitization, is very much diminished, then of course your whole system becomes a bit shaky. If all those default small claims or whatever go unnoticed digitally, then of course your system becomes shaky. And then our final question in the introduction was, should special forms of procedure be limited or controlled? And there I have to admit that I may be a bit less reluctant than some of their colleagues that very much focus on we should not have the primary focus on efficiency. I do agree with that, but I also do believe, and that is what was, for instance, also illustrated by US law, Brazilian law, in the multi-house corridor, or as I've called it a few weeks ago in Chile, where I was with Alan, among others, a tailor-made justice, or a justice in a tailor-made jacket. So not all procedures and all types of measures need a full-fledged procedure. We just cannot afford and allow that, and it's also not in the interest of parties. Soraya ends in her chapter or her introduction by a quote of Cappelletti, and we had the quote here, and I will not quote it now, but the idea here was, because otherwise it's a bit of a long sentence, but that we have to, ideally every case could go to court and have a full-fledged procedure, but that's not doable. But we have to avoid that in the race for more efficiency, we lose the social face of justice. Thank you very much.
Thank you very much. And yes, efficiency and proportionality, I think we can also come back to that and to find the right balance between cost efficiency justice and procedural justice. I think it's something we really have to keep in mind. And also, I think that your conclusion that special form of procedures become or are the main procedure, I think it's also very important. This is a major trend in civil procedure, and I think it's very important because we all teach civil procedure, and we focus on very important cases for the full Monty justice and special forms of procedure. Of course, we deal with them, but in very short manner. Thank you very much. I think, again, we have really interesting insights about special form of procedure, but also the challenges of comparative civil procedure. So the floor is yours. Yes, Anne.
I was admiring this effort to systematize something that is very difficult to be systematized. I tried now to go through Soraya's introductory chapter. But still, I cannot escape a conclusion that this part is an attempt to provide some kind of doctrine or theory to a basket in which we are throwing a number of things that are basically very different and almost incomparable. Let me start with the idea of special forms of, and now I'm pausing because on the screen we see litigation and in the program we see procedure. Well, special forms of litigation in our conventional view were specific procedures which are adjusted to subject matter of procedure, but then we have another chapter which deals with commercial cases and stuff like that. Is it special form of litigation? Is default procedure a kind of litigation? Is the basically procedures which certify uncontested debt, so uncontested debt certification, is it a litigation or is it a pre-litigation procedure? If you put in default procedures, which are part of litigation, you don't speak anymore about form of procedure or litigation, but the procedure within the procedure. So I think that we still have a kind of a systematic problem here. So maybe it would be much more, well, at least frank to admit, well, we didn't know what to do with all of these things, so we just threw them together into one mass. My fear is that if we are trying to put on a doctrine on something that is inherently difficult to put together, then we're not doing a favor to our main effort, which is to provide some kind of a compendium or encyclopedia. And we have to be aware that maybe somebody will use this project as a normative project, like setting what is the state of the art today in civil procedure, creating categories which are probably not good science. Thank you.
I disagree a little bit, but I prefer that Professor Hess speak before me and maybe a lot.
I mean, that's certainly the point to some extent, that it is difficult to put many different variations of procedures under one heading. But actually, if you look at the introduction, I found it very good both for efficiency as an overarching idea, but addressing it also with a critical distance. Asking, well, we have in many areas simplification, accelerations of proceedings for good reason. Maybe it's not litigation, it's maybe pre-litigation, but we can go back to proceedings, no problem. But then we really have a phenomenon which we can categorize to some extent. This does not mean that this is the only category to be applied, but within an overarching project on procedural law and dispute resolution, I think it makes sense to have this category. And I had the impression we have even seen that it makes sense.
Maybe, yeah.
Yeah, indeed, in our, we also were a bit lost at the start, but I think we all were, and that is how we found our way by first getting lost. Indeed, we had this delineation with other special types of procedures. For instance, one of my research interests is also special procedures for big commercial claims, the international commercial courts, but that was in another chapter. So we looked at what is in the other chapters and what makes sense, what is sort of an overarching theme that we can include in our chapter. But I think we also, in the introduction, but also in the different parts, we acknowledge that we try to categorize because we want to compare, we want to see if there are common denominators, what are the common denominators and also the main differences. So I think indeed that makes sense, and we acknowledge that sometimes we throw different things in the basket. And also, as I said in my presentation,
in the end, you have to look at the system as a whole, and you cannot take every individual procedure and just say, oh, that belongs to that category. Some are very clear, like small claims, but even small claims in one country, that's 500 euros, in another country, that's 25,000 euros, and everything in between, and also the forms and procedures differ a lot. So I think it makes sense. For provisional measures, and there you're very right, but to a certain extent also for some other procedures, last year I started my, because I still had my text from there, that provisional measures are a special type of special procedure in terms of it is not even a real procedure, or it may just be a provisional measure that functions within the context of an existing procedure as an interim part or preceding an ordinary procedure, because maybe you have to start main proceedings within a certain period of time. But then still, the way that these measures are granted lead to a special type of procedure. So it would belong in that category. And for instance, default procedures take the place of other procedures. If the defendant doesn't show up, then we replace it by that, and then it's treated in a separate way, and then it becomes a separate procedure. And also for early dismissals, of course, that starts as a normal procedure, but it ends in a special way, looking at certain features of this procedure. And that is why we thought, well, mapping all the diversity of these procedures and trying to categorize them to a certain extent was a nice exercise.
Yeah, just although it's not an autonomous category, it made sense at the end for scientific purpose to see them as a whole. Because of this, sometimes the strategy is not opting for one special procedure, but for another. And we could also see the evolution of the special forms of procedure. We could see the things that they have in common and the differences. So I think at the end it made sense.
I admit that the classification is somewhat problematic because there are many different things in this ball. But at the same time, I think we haven't not pretended to build a general theory about all these categories. We have dealt separately with provisional measures, special forms and procedure. They have also closely related sometimes because they are provisional measures that develop to special procedures also. You don't have to continue proceedings when you have been satisfied with it. But I admit this is a somewhat problematic categorization, but the important is not the classification, but the content. And in this way, I think we have distinguished variations.
I think we have
the
last question.
Only a remark from an Italian point of view, it makes sense to have such a chapter. I fully share Burkhard and Sandra point of view. We had in Italy a big debate, a big discussion about the so-called differentiated protection of right. We played a big role in Latin America, for example. It's very, very important to give us some historical viewpoint. The starting point is we used to have only an ordinary normal city, and then as society developed, it became more and more proceedings, giving a special proceeding for workers. This is the first example of a special proceeding, distinguishing from the normal proceeding for the bourgeois. And it is, of course, I would try at the very end to give some general thought, not about this historical development. Not only focusing on the actual state of play, but seeing in an historical perspective would be interesting. Thank you.
Thank you very much. I would like to thank all the intervenants this morning. It's time for a coffee break and a photograph. Do we? Yeah, okay, go to the photo first. You're right.